All rise. Hear ye, hear ye. The Court of Appeals of the State of Michigan is now in session. The Honorable Peter D. O'Connell, the Honorable Amy Ronaine Krause, and presiding the Honorable David H. Sawyer. All persons having business therein, draw near, give attention, and you shall be heard. I say to these United States, State of Michigan, and this honorable court. Please be seated.
Good morning and welcome to the final session of the Michigan Court of Appeals for the 3rd District, sitting in Grand Rapids. To my right is Judge O'Connell from the 4th District, and to my left is Judge Krause, again from the 4th District. The first case on our docket is 30-14-43, People versus Rodney Koon. You may proceed.
Thank you. Good morning, Your Honors. I'm Jennifer Taney Anderson on behalf of the people of the state of Michigan from Grand Traverse County. I intend to use 15 minutes initially this morning and request to reserve 5 minutes for rebuttal. I'd also like to allow 10 minutes for the amicus. Linus Banghart, on behalf of the Attorney General's office, is also appearing today. Your Honors, there's zero tolerance in Michigan for operating a motor vehicle with the presence of a controlled substance, and the Medical Marijuana Act does not change that. Marijuana does remain a Schedule I controlled substance. And in a state where we love our cars, it is especially important that we protect those using the roads and highways, those driving and pedestrians alike, from possible hazards, including driving while intoxicated. Now, the defendant in this case is, of course, charged with violating Section 8 of 625 of the Motor Vehicle Code, driving with the presence of a Schedule I controlled substance, that being marijuana. Again, the Medical Marijuana Act does not change that. The Medical Marijuana Act allows for protection from prosecution or an affirmative defense for use of marijuana cultivation and limited transfer. It does not...
there is no, I'm sorry, but there is no definition of under the influence in the Medical Marijuana Act.
That's correct. I agree.
All right.
Your Honor. And in fact, maybe that'll just go right to my next point. And under the influence, as it appears in Section 7 of the Medical Marijuana Act, because it's not defined, and because this was a ballot initiative, it should be presumed to have the common meaning that the general public would attach to it. However, in Michigan, the drunk driving laws, 625 is called operating while intoxicated. Most people don't realize that under the influence is a term of art when you're talking about the operation of motor vehicles, as is impaired driving and as is a per se violation, such as the presence of a Schedule I controlled substance is a per se violation, so is the .08 law, the .17 law, and zero tolerance, meaning the minor drinking, with .02 to .07 operating a motor vehicle. All those things are encompassed under operating while intoxicated. When the people of the state of Michigan passed this ballot initiative saying that they wish to have chronically ill people with debilitating pain be able to use marijuana for medicinal purposes, I don't believe they were envisioning people smoking and driving. The idea was this is accepting people from prosecution for using medication to try to ease their pain. There's nothing in the Medical Marijuana Act that suggests that the people or the legislature intended to allow driving while impaired, which if you use the defense's argument or the appellee's argument, and only under the influence of marijuana, driving under the influence of marijuana is prohibited, then you would actually be allowed to drive not only with the presence of active THC, but you'd also be allowed to drive under the drive impaired. That doesn't make any sense at all, and when we're looking at general construction of the laws, we want to look at everything all together and try not to negate any particular part of one law or another. So I'm suggesting that really there is not a conflict. And when you read under the influence in Section 7 of the Medical Marijuana Act, you look at it as what the general public would mean by under the influence, and including all three under the umbrella of operating while intoxicated, as we have in Michigan. That being the under the influence, the impaired, as well as the per se violations that I just previously listed. In fact, other states, as you know, reference drunk driving as DUI. Most states don't even have impaired driving anymore. Michigan is unique in that way. And I just emphasize again that the Medical Marijuana Act did not alter Section 7212 of the Health Code, meaning that marijuana remains a Schedule I controlled substance. And this court has even ruled that in the recent past that remains a fact, despite the fact that there are allowances for medical use of marijuana for the chronically ill and debilitated people.
I'm sorry, could you make that point again?
Sure. Recently, even this court has noted that marijuana remains a Schedule I controlled substance, despite the fact that we do have allowances for use for medical purposes, meaning it hasn't been switched to a Schedule II controlled substance. And there isn't, without changing the schedule of the drug, you still have to follow Section 8 of the Motor Vehicle Code, where you can't operate a motor vehicle with any Schedule I controlled substance, and that's what we have here in this case. THC, and this is active THC that I'm talking about, is an inherently dangerous drug, and we must continue to have zero tolerance for driving with the presence of marijuana or active THC to maintain public safety.
Well, they argue that the Medical Marijuana Act supersedes. This was done after, obviously it was passed and promulgated into law after the Motor Vehicle Code, which has the tolerance level of zero tolerance, which, as you said, and the .08 and all the others, Schedule I. So they're arguing that this would supersede it. However, and I think the district court bought that, and the circuit court bought into that, indicating that they were going to give an instruction, and the instruction was material substantially impaired by the use of whatever. How do you argue that this isn't superseded by?
Well, it's not. It doesn't state that it's superseded by that. The Medical Marijuana Act doesn't purport to regulate driving. Even when you look at that first section.
Well, if you read the medical marijuana law, it says medical marijuana registered car holder not subject to arrest, prosecution, penalty, and it goes on like this.
Right, but that's for use of marijuana.
I understand.
And Mr. Koon is not being prosecuted for use of marijuana. He's being prosecuted for driving behavior, not the use. And I would also point out that the drunk driving statute, Section 625, was amended last year to add the high BAC law, or super drunk as some people call it. So 625 paragraph 1C was added, and there was nothing done to paragraph 8. So it seems to me that if there was some intent to change that, it could have been done last year when they were actually looking at the drunk driving laws.
Thank you.
So I do ask this court to please reverse the decision of the circuit court and remand this case for trial with the jury instruction consistent with paragraph 8 of 625 of the Motor Vehicle Code. Thank you very much.
Thank you. Any questions? Thank you very much. You have time for the vote.
Good morning, Your Honors. May it please the Court, Assistant Attorney General Linus Spang-Hartlin, on behalf of the amicus curiae, the Attorney General Bill Schuette, who join the people today in requesting that this Court reverse the erroneous decisions of the lower court and urge this Court not to adopt any interpretation of the MMMA that is going to allow medical marijuana patients to drive on Michigan roadways with active THC, a known intoxicant, in their systems. As my sister counsel said, nothing in the MMMA has repealed subsection 8 of section 625 of the Motor Vehicle Code. In fact, this court has held that the MMMA didn't repeal any portion of the Public Health Code. It's an even further stretch to say that it repealed some portion of the Motor Vehicle Code.
Michigan voters have allowed the use of marijuana now. At least they have stated it in a referendum, it's put into law. Just like under prohibition, we now don't have prohibition for alcohol, and alcohol is now okay to drink or do whatever. But you cannot drive an automobile if you're materially or substantially impaired by the use of alcohol.
Certainly.
Or there's a per se 0.08. Right? Well, what's the argument that when the voters and when we have the Medical Marijuana Act that then says, okay, here we are, marijuana is okay to be in your system, to walk around, if you're legally card-carrying marijuana user, I guess is the way to look at it, I guess.
Yeah.
Why shouldn't there be you could drive with it now as long as you're not materially and substantially impaired? And what the district court wanted to do was to say, okay, you can charge this individual for smoking marijuana or having THC in one system as long as that individual isn't materially substantially affected by the use of it while driving. What's the difference?
Well, that's a policy decision that the people didn't make when they passed the MMMA, and that the courts are not empowered to make as a public policy decision, because the MMMA didn't purport to change explicitly and can't be read to change implicitly this per se limit. Now, as Your Honor noted, there is a per se limit on alcohol, despite the fact that alcohol is generally legal. And although marijuana remains illegal with certain protections against prosecution, there is a per se limit with marijuana. It happens to be
zero tolerance.
It happens to be that the per se limit is 0. That's a choice that the legislature is allowed to make. The MMMA could have changed it. The MMMA did not change it. The MMA, Section 7B of the MMMA, which is one of the things that the defendant needs to win here, is a list of things that remain illegal. It is not a list of things that the MMMA outlaws. It's a list of changes that aren't being made. And so it goes way too far to say, well, because we have a list of things that remain illegal, anything not on this list has
Your
to
argument is basically that the legislature wants to treat this the same as alcohol. They should go back and look at it and amend the motor vehicle statute dealing with the drunk driving statutes to put something on it if they wanted to, or leave it the way it is.
Leave it the way it is I think what we would, yeah, exactly.
Yeah, but then we have the legislature, and that's certainly not the courts, and you're saying by the courts giving this instruction, they in essence, in fact, have abrogated the will of the legislature on the motor vehicle code.
Exactly, by working a repeal by implication, and repeals by implication are disfavored. There's no explicit repeal of the motor vehicle code. Section 7E, which is another thing, the other piece of the puzzle for the defendant, says that parts of acts inconsistent with this are not in effect, let me get the actual language, just so I'm not misquoted, do not apply to the medical use of marijuana. And as my sister counsel noted, medical use of marijuana is not an issue in this case. Medical use is defined in the statute to include a number of activities, none of which are driving with THC in the system. So even 7E doesn't work because we're not in the realm of medical use. We're in the realm of public safety. And there's nothing about a medical marijuana card that makes someone a safer driver when they have THC in the system than someone without a medical marijuana card. And because the purpose of the motor vehicle code is to protect public safety of the roadways, the public safety question hasn't changed. If we want to protect these people from prosecution because we're feeling compassionate, that's fine, but then they have to make a choice. Just like when you have prescription medications, chemotherapy, outpatient, you make a choice. You take the bus, you stay home, you get a ride from a friend, and that's all that's being required here with medical marijuana. If you have THC in your system, you stay home, you take the bus, you get a ride with a friend who doesn't have THC in his or her system. That's the plain language of the statute, and they didn't change that. And for all of those reasons, we urge this court to reverse the decisions of the lower courts.
Thank you very much.
Thank you, members.
You have time for rebuttal.
Good morning. My name is James Hunt. I'm the attorney for Rodney Koon.
Mr. Hunt, it's a pleasure to see you again. It's been a number of years since you last argued in my court.
Yeah, unfortunately, it has been a number of years. I'm going to put my glasses on too so I can see everything that's here. I think the arguments have been laid out pretty straightforward here. The issue is whether or not the medical marijuana statute, by its language, was giving a restriction on the use of marijuana where you cannot use marijuana to the point where it would affect your ability to operate a motor vehicle under the influence of liquor. Although the medical marijuana statute does not have a definition of OUIL as we under the influence of drugs. Although the medical marijuana statute does not have a definition of operating under the influence, clearly the jury instructions do, and it's not something which is misunderstood by most individuals. As you pointed out, if a person is materially or visibly impaired by the consumption of either drugs or alcohol, then they can be convicted under the statute. We're not looking at anything different than what the Attorney General was talking about when we're dealing with prescription drugs that under normal circumstances.
How about the argument that they make is that the motor vehicle code does have certain strict standards, zero tolerance, if you will, for minors, zero tolerance for Schedule I drugs. And the Medical Marijuana Act doesn't address any of that, but leaves it intact, and the legislature didn't do anything about it.
Well, what it says, I think it does affect it when you look at the Section 7, where it says that a person who has a medical marijuana card is acting under the statute, cannot not operate any motor vehicle while under the influence of marijuana. I think it clearly indicated that it understood that an individual may have THC in their system, but until it gets to the point where that person is under the influence, then they can still operate a motor vehicle. And I think when you're looking at Section 7E, where it talks about all other acts and parts of acts inconsistent with this do not apply to the medical use of marijuana, I think that by its statement would take away the zero tolerance part of Section 625. Again, we're not dealing with a situation here any different than we are with an individual who's taking a prescription drug. As the Attorney General pointed out, it's not illegal to operate a motor vehicle with a prescription drug in your system, although it is illegal if it affects your ability to drive. And that's true whether or not it's a...
But any Schedule I, if you have any Schedule I drug in your system, even if you have, I mean, it doesn't matter. Any amount is going to be enough. And my concern here is I don't see where the legislature changed this from a Schedule I drug. It's still a Schedule I drug, even though the definition of Schedule I isn't met anymore. It's still a Schedule I.
Yeah.
And so when we say under the drunk driving code that we're not going to allow people to drive with any controlled substance that's a Schedule I in their system, I don't see how you get around the fact that it's not changed from a Schedule I.
Well, I understand it's not a Schedule I. The language of Schedule I says that there's no medical use for the drug that's involved. I mean, we're dealing with drugs that have a high potential for abuse and have no recognized medical use. Now, when you have a situation where there is a medically recognized use, and that's not just in assumptions, that's based on scientific proof that there is a medical use for marijuana. Then it really, is it still defined as a Schedule I drug? Maybe we have it in the statute as that effect, but does it fit the definition?
Right, but we can't change that.
I understand, but it does it. I know the dissent, or I guess the concurring opinion of Judge O'Connell in Redden said, gee, it would have been nice if the statute itself would have addressed the issue and said, okay, it becomes a Schedule II or a Schedule III. And I don't know if you can argue that in 7E that it would have done that because obviously it's inconsistent with that statute. That statute says there's no medical use. We've now recognized there is a medical use. Is that inconsistent and no longer would make it fall within the Schedule I language? Again, I understand the idea, and I agree that it would have been nice if the statute was more explicit in a number of different areas.
Right.
It's been pointed out in a number of decisions. It was artfully drafted, and unfortunately, when you have a statute that's passed by the public and not something which is argued and back and forth within the legislature, it makes it extremely difficult for interpretation. But I think that in this particular case, I think it was clearly understood that medical marijuana has a valid use. We don't want to endanger the public. We don't want people under the influence of marijuana to be out there driving. That's why we put that in there. But we don't necessarily believe that we're impacting the public safety merely because marijuana is in their system.
Okay, and Mr. Hyman, you're going to have to put up with me for just a little
bit
because I'm the new person here. These two are very experienced and they've dealt with this issue before. This is my first time dealing with it on this court. So, here's one of the things I was thinking about with Section 7, because I think Section 7, and I really want to understand from where you're coming on this, because my concern about Section 7 of the MMMA it seems to me that that section essentially strips a medical marijuana card holder of their status as a medical marijuana card holder at that point. Because they're saying these are things you can't do. And one of the things is you can't undertake any, this is just an example, undertake any task under the influence of marijuana when doing so would constitute negligence or professional malpractice. So if you're practicing and you have a medical marijuana card and you're a lawyer, how are you giving advice? I mean, if somebody came in, when I was a district court judge, came in with marijuana in their system, I wouldn't take a plea from them. No way. I mean, I wouldn't do it. If you were under the influence, if you had any marijuana in your system, I wouldn't take a plea. Because how can it be knowingly and understandingly? And then we get to driving, and now, I guess my question is, when is it illegal to drive with a controlled substance in your system then? Never? I mean, how do we have to decide? How do we decide that? Because the statute says any presence is enough. So I know that's a lot of questions all in one, but you see, I'm concerned about the circular logic here.
Well, let me kind of address it separately.
Okay.
In subparagraph B1 that you're talking about, undertake any task under the influence of marijuana.
Right.
You're assuming that the presence of marijuana would mean under the influence of marijuana for purposes of that paragraph. Not for purposes of the motor vehicle code, but for the purposes of that paragraph. So if you had an attorney who was practicing law in front of you that had a medical marijuana card, that was not driving, that was not doing anything inappropriately, but appears in your courtroom merely because he has THC in his system that he's under the influence. And I don't think that's an assumption that you can make, and I don't think that's what the studies actually show.
Okay.
And I don't think that would be true if you had a defendant that was charged with assault and battery, disturbing the peace, whatever it might be. You can't assume merely because that person had marijuana in their system that they were under the influence.
All right, that's fair.
The Schedule I statute, again, was passed with the understanding that you have a drug that is subject to abuse and has no medical recognized purpose. And so it said any of that in your system, period, it is going to be sufficient to say, we're going to disqualify you from driving because there's no reason in the world why you should be able to use it. With medical marijuana, you now have a substance where it's been recognized there is a medical benefit to it. And we're not saying that anybody can use marijuana and can go out and drive at any point in time. Clearly the problem with this case, it was recognized by the prosecutor, my client got pulled over for speeding. He was passing a car, the officer was coming the other way, he was pulled over for speeding. There was no indication of impairment whatsoever. The only way this issue came up was that he was told the officer he was a carpenter, and the officer says, well, gee, you may have some type of weapon on you, so I'm going to pat you down. He found a pipe, and there was a smell of marijuana in the pipe. That's how this whole arrest came up. So there was, what the judge was saying is that, okay, under this scenario, and under this particular set of facts, you obviously have no bad driving, you have no indication he was under the influence of marijuana. We have a person who has a valid medical marijuana card. We have a statute that says you can't operate under the influence, and we all know what operate under the influence means. And I disagree that the general public would believe that operating under the influence means the per se statute, because I don't think the general public understands the per se statute. And so all the judge was saying, okay, if you're a valid medical marijuana card holder, if you operate a motor vehicle, you have to understand you're taking the risk that if you are under the influence of that drug, that you are going to be convicted, and you're going to be convicted under Section 625, just General 625. So we're not trying to add anything to that, and again, we're just trying to say that these people have to act responsibly like anyone else has to act responsibly. And if there's a field sobriety test, if there's indications of thought processes, coordination, speech, reaction time, whatever it might be, that are detectable and that person's operating the motor vehicle, they're wrong. It's illegal.
So in substance, you're arguing, and I take it for listening to you, that the Medical Marijuana Act overrides the MCL 257.625.8.
Correct.
Because it's implicit in there that, as you just described, that it's okay to be in your system, but you cannot operate. Therefore, that was passed after and overrides the...
Correct. And the high DHC statute never addressed that.
Let me just follow up with that.
Okay.
But you're not saying it overrides 257, 625 in general.
No,
You're
not
saying
at all.
it overrides 8. It doesn't override 1 that talks about you can't drive under the influence of alcohol or drugs.
Correct.
Okay.
Correct. It's only that per se portion
eight.
of section 8.
All right.
So far, so good, Mr. Hunt.
I understand, Judge.
Might have a few questions though,
Sure.
for you.
Sure.
I have no idea what the word override means. So let's talk in terms of what we do know.
Okay.
Are you telling this court, or representing to this court, that the MMA repeals any acts either in the Public Health Code or in the Motor Vehicle Code?
Well, what specific section? I mean, we're talking about Section 8 of the Motor Vehicle Code. We're saying that my argument is that that's no longer applicable based upon this statute. Are you talking about whether or not...
Your argument is that it repeals 625 subsection 8 of the Motor Vehicle Code.
If you're a qualified medical marijuana user.
Now, see, there's a small problem with that occurring because you have a title object problem then, because there's nothing in the title object of the Medical Marijuana Act that says it repeals any acts in the state of Michigan. If we were to buy that argument, Mr. Hunt, we would have to declare the entire Medical Marijuana Act unconstitutional for violation of title object. Now, as we do know, Michigan law favors not repealing any law either directly or it can do it directly, which this Medical Marijuana Act does not do.
I agree.
And it can't do it by implication. Therefore, we're going to have to find some way, if we want to save the entire Medical Marijuana Act, if we want to save the entire thing, where we can find that there's no conflict between 6258 and 4B. Follow me so far?
Okay.
Otherwise, we lose the whole act. This is going to be a problem also with preemption if the Medical Marijuana Act gets on the ballot, because then we're preempting the entire, we, Michigan, by constitutional amendment, are trying to preempt federal law. And so that whole new act, if it gets passed, may go down also. But so far, we're not going to talk preemption here. We're only going to talk title object.
Okay.
If it doesn't repeal any act, which it better not, because then we lose the whole act, what does it do? What does the Michigan Medical Marijuana Act do in reference to any of the existing acts, which is the Motor Vehicle Code and the Public Health Code?
And I'm assuming the Public Health Code, you're talking about a Schedule 1 drug? Is that?
I'm talking about any drug laws all of our drug laws are contained in the Public Health Code.
I understand, but I don't know what specific provision of the Public Health Code you are concerned about.
Anything to do with marijuana? Does it repeal those provisions? And the answer, let me help you out. The answer is no, it does not.
Yeah, it doesn't, because clearly this is not overriding, say, possession of marijuana or use of marijuana is legal. It only makes a statement that if a person is a qualifying patient under certain circumstances, they have a right to possess or use marijuana.
No, they don't have the right to possess or use marijuana because it's still unlawful under the Public Health Code.
Okay.
What they have is they're entitled under Section 4B to immunities. I think that was Judge Kelly's opinion. They're immune. Now, this is sort of an interesting thing. You've got the medical marijuana law that provides an immunity against a prosecution. It's still illegal, but you have an immunity. You have protections under 4B. Would we agree with that so far? In part.
4B?
4B is the section that grants immunities to anyone who has a medical marijuana card.
Sure. I was looking at 4A.
4A also is applicable. 4A is applicable to people with cards. 4B is people with cards who are caregivers.
That's correct. B provides for caregivers, and A is for the actual card.
Okay, so follow me so far.
Okay.
So we've got an act that doesn't repeal any acts, doesn't repeal the Motor Vehicle Code, doesn't repeal the Public Health Code, but grants immunities under 4A and 4B.
Okay.
Now, 4A and B grant immunities for what? Medical use. I think we've talked about that, but it only grants it for medical use.
Okay.
Now, if we turn to the definition section of medical use, we're in trouble. And the reason we're in trouble because it doesn't say anything about motor vehicles. So I'm asking this, as long as you followed me so far, which I think you have, because
Okay.
I've known you for years. It's not hard to follow.
Yeah.
Where in medical use does it allow you to operate a motor vehicle?
I don't see any language that exists in the definition of medical use that would say you can operate a motor vehicle, because I don't believe that was ever anticipated, that when you're defining medical use, how something is used, that you're going to be talking about all of the other implications of marijuana, period.
When I was thinking about this last night, I thought of the word that came from Roe versus Wade. It has to be a penumbra of medical use. It's the only way you're going to get there, okay? An extension of medical use. Because there is no immunity and there is no protection for operating a motor vehicle.
Well, again, I think that's where Section 7 comes in, but we disagreed with
Well,
that.
you
It's
don't get to
almost-
Section 7 unless you have an immunity or a protection for that particular activity.
Well, and Section 4A says that you're not going to be subject to arrest, prosecution, or penalty in any way, or denied any right or privilege. Now, driving is either a right or a privilege, and if you decide it's a privilege, then obviously it does apply to driving. I mean, what other...
Well, no, because if you're granted a protection or you're granted immunity, it's not an extension of something. It has to be a specific grant.
It says that you're not subject to arrest, prosecution, or penalty in any manner, or denied any right or privilege for the medical use of marijuana in accordance with this act.
And it's for medical use. Now let's
Well,
go
it
figure out
says-
what does medical use mean.
Well, then you have to look at it in conjunction with the balance of the statute. I mean, when you're talking about arrest, prosecution, or penalty, or denied any right or privilege, you're not talking about just medical use itself, because that's the modifying
That's the
factor.
only thing that you're granted protections for,
Correct.
is medical use.
No, it says when you, I guess if I had to simplify this in my own words, if you use the medical marijuana in the way you're supposed to use it, then you can't be penalized. You can't be arrested, you can't be denied a privilege, you can't be denied a right.
Go ahead and read the statute.
I thought I had done that. It says, shall not be subject to arrest, prosecution, or penalty in any manner, or denied any right or privilege, and then I'm going to skip the part about disciplinary boards, for the medical use of marijuana in accordance with this act. So if you are saying you're going to be not denied a right or a privilege to operate a motor vehicle, even though you're using the medical marijuana, according to what you're permitted to do, you have the appropriate amounts, you're not under the influence of marijuana, you're not doing anything inappropriate, then how can you be prosecuted? I think that...
Because medical use is specifically defined in the Medical Marijuana Act under the definitional section.
So what privilege, I don't know what privilege you would be denied. I mean, we're talking about
The
criminal...
privilege to
penalty.
use medical marijuana, the privilege to acquire medical marijuana, the privilege to transport medical marijuana are all included in the definitional section. And for some reason, they didn't include the privilege to operate a motor vehicle.
Well, and I think that's a very strict reading of that when you look at it, when you say...
There's no
denied.
question, Mr. Hunt, it's a very strict reading of it.
Well, it is, because when you read that statute, again, you're denied any right or privilege. And then it goes on and it says,
But
including but
how
not
can
limited to
how
civil
can we jump to the
penalty.
next section and say that any right or privilege, now, here's where it's really going to get complicated. If that's the case, then you're telling me an airplane pilot, such as Judge Sawyer's son, who happens to work for Delta or United, can smoke marijuana and fly an airplane with 722 passengers on it, or 300 passengers on it, depending on whatever passengers. Are you representing to this court that this act, and this is the tough question, this is where I was going the whole time, can fly an airplane while they're smoking marijuana? As
Well,
long as it doesn't affect their ability to operate that airplane?
No, because you're talking about a state statute here, and you're talking about federal regulations of the FAA, which are totally
Well, let's say
separate.
Michigan has their own, they do, the FAA. Michigan has their own regulations for flying airplanes, which of course is, hopefully doesn't contradict with federal regulations that say you can't have any controlled substance within, I think it's 24 hours before you operate an airplane. The same section that you're relying on, which is 7B4, says operate, navigate, or an actual physical control of any motor vehicle, comma, aircraft, or motorboat while under the influence of marijuana. So it's a parallel argument. If you're saying this applies to motor vehicles, then it also applies to airplanes.
And apparently it would also apply to motorboats, but it doesn't necessarily mean that you're looking at a commercial issue there. I mean, I'm not familiar with the FAA. I'm not familiar with the state FAA. All
I think what Judge O'Connell's pointing to is that if in fact this opens it up all the way, not just dealing with driving an automobile.
But it's even worse because it violates the title object. If we were to interpret it your way, it violates the title object, and the entire Medical Marijuana Act is then declared unconstitutional for violation of title object. And that hasn't been briefed.
I agree.
It's the very next argument that's going to come out of this.
Sure.
As I said, the other argument of whether or not Michigan law can preempt federal law may be on the ballot this fall. And then you've got even a bigger problem for the entire Medical Marijuana Act. I'm just pointing these things out at this point in time. I'm asking you how far you want us to go.
Well, Your Honor, I guess what my argument is obviously limited to the scenario that has been presented before this court. Does the medical marijuana statute at least take away the Section 8 of MCL 257-625, where the mere presence of marijuana makes it illegal to operate a motor vehicle?
See, your position requires us to repeal, either directly or by implication, a provision of the Motor Vehicle Code.
Unless you're talking about the same arguments you made about immunity that was made for other purposes. I mean, again, if you look at Section 4A, I don't believe it's that much. I don't think it's a stretch to say you're granting the same immunity under that circumstance. You're just saying that person can't be under the influence.
But the difference between the Public Health Code and the Motor Vehicle Code, okay, is you get immunity against prosecution for the medical use under the Public Health Code. The definition doesn't provide immunity for operating a motor vehicle unless we want to read into the statute that you can also medically use it and do something else, such as fly an airplane or operate a motor vehicle. And I understand your argument, Mr. Hunt, which is a very good argument, that inherent in this immunity, inherent in medical use, is the ability to do what a normal person would have the right to do within society, which includes operating a motor vehicle.
Correct. Any other questions?
I'm going to take us back to driving an automobile.
Okay.
Okay. I want to just talk a little bit about how the impact of this, because, and I want to make sure I understand your argument. Your argument is that the amount of THC would have to impact the driving for the person to be under the influence if they have a medical marijuana card, correct?
That's correct.
Okay. So, here's one of the issues I see is that, and I know a lot about in terms of having people in my court. We don't have people come intoxicated here, which is nice. But in district court, I would have people come intoxicated to court quite frequently. It was a little shock to me when it happened, but and they would walk in, and sometimes the person would seem absolutely normal to me, walk, talk, absolutely fine, and my law clerk would come up and say, Judge, I think this person's been drinking. Okay, so we had them take a PBT, and sure enough, they are 33. And they're walking, talking, and they look completely fine. Now, let me go back again. Here's another case where I'm not going to take a plea from him at a 33. I don't care how well he's walking and talking, right? So my question is, we don't have a level regarding a controlled substance. So if, in fact, a medical marijuana card user builds a tolerance, they could have a tremendous amount of THC and it wouldn't impact anything. And you're saying that it would have to be legal under the law because they're not technically under the influence. Do I have that right?
Well, I guess it depends. Let me take it another step.
sure,
And
okay.
I guess I'll just go back to my own experience with our circuit court
Okay.
in Grand Traverse County.
Sure.
One of the things that they
He's a
always
great
ask,
judge. He's a great judge.
one of the things they always ask when they're taking a plea is, have you taken any alcohol or prescription medication within the last 24 hours? And a lot of people have prescription medication, whether that's pain pills, whether or not it's some antidepressant or an anxiety pill. And they ask the individual, you know, okay, did you take it according to prescription? Did you take any excessive amount? What effect does it have on you? Are you able to understand what's happening here today? They may ask them a number of questions to make sure that they are not under the influence of that drug, at least under the influence to the point where they can't understand what would be happening. Obviously, they're influenced by it. It's just a medical influence that would be there.
I understand.
So all we're saying, and again, I understand that there's no recognized study that says that if you have this much THC, you're obviously impaired. It's not like we have with alcohol. Those studies have been done to some extent, but they have not been done extensively enough to come up with a known number. And I understand your problem. I guess at a 33, obviously the person could not drive. I've had individuals call me in the middle of the night and say, do I take a breath test? They sound perfectly normal to me, and I find out they had a 16 or 18 the next day. You know, it's when you look at under the influence, what it means under the motor vehicle code, when you look at the jury instructions, that person's ability to walk, talk, perform acts, to their mental acuity, their ability to do certain things has been either visibly or materially impaired by the consumption of alcohol or the illegal drug. And I think that's the factor we look at. And I understand the concern you would have in a courtroom because you're taking a plea and doing whatever, but I think we just have to look back at that definition under the jury instruction to be able to say, what does this mean? We clearly have a definition. I think
Judge Krause has pointed out that under the influence, under the drunk driving laws, may have a different meaning. May have a different meaning. Go back to the common understanding of that particular meaning. Go to the dictionary definition of that particular meaning for the Medical Marijuana Act than it does under operating under the influence of alcohol. If she were to define it in that manner, that would get rid of the title object problem. That would get rid of the repeal by implication problem. Of course, for your client, it wouldn't it wouldn't serve the proper purpose while you're here today. I'm just pointing that out. That's one way of saving the act.
Sure.
But you have presented us with a very interesting issue.
Thank you. Any other questions?
No, that's all.
Thank you very much.
Thank you very much.
It's a nice job.
Yeah, very nice job.
You, Bob?
Thank you, Your Honor. In response to the appellee's comment about under the influence not being a misunderstood term, misunderstood, maybe not, but I would like to point out in the circuit court's decision, the judge interchangeably used impaired and under the influence, and they are not the same thing in Michigan. So I would like to point out that even lawyers use under the influence to encompass all those three things I mentioned earlier in my original argument. Secondly, the appellee argues that this isn't different from any other prescription. On the contrary, it is. This is a Schedule I substance, and it remains a Schedule I substance. A Schedule I substance can be determined, I guess, or has two definitions, has a high potential for abuse and no accepted medical use and treatment. I submit to you there is no proof that it still doesn't have a high potential for abuse. There's accepted medical treatment in at least 16 states that have laws similar to ours. Or Schedule I could be it lacks accepted medical use and treatment in the United States or has severe restrictions. So it's not like any other prescription in Schedules 2 through 4. Marijuana is still a Schedule I controlled substance, and therefore the prosecution under paragraph 8 of 625 of the Motor Vehicle Code still is in full force and effect. Additionally, appellee states there was no bad driving in this case. That I would have to differ respectfully that 83 miles an hour in a 55 zone, not only is that speeding, that's probably reckless, maybe not under the influence, but I consider that to be
Of
bad.
course, that would be an issue of fact, would it not?
Absolutely.
If it went to the jury,
Correct.
If we,
I agree, it is factual, but I can't let that go without saying there is no bad driving. That's an issue, factual issue yet to be determined. Finally, Judge O'Connell, you sort of stole a little bit of my steam in that I was going to go back and read medical use of marijuana as defined under Section 3, Paragraph E, and point out that you can use medical marijuana without driving. You don't have to drive if you're using medical marijuana. And as you said, it is defined in the statute, and nowhere in there does it reference driving or other activities. It's a very explicit definition. And furthermore, the people who are using this medicine, the medical marijuana, don't lose their licenses. They retain their privileges if they already have them. It's merely that you can't drive with active THC. We're not talking about carboxy-THC, the metabolites. We are talking, and I believe both sides, the amicus curiae and the defense cited or used some studies that suggest that within a couple hours, the active THC is out of your system. So we're talking about a couple of hours. We're not talking about days and weeks that people can't drive. And I'd also point out that the seriously ill, debilitating pain sufferers would in theory be a small number who are truly affected with all these terrible things. So this isn't like we're talking about the whole population of Michigan. It's a small population. And frankly, if you're ill and under debilitating pain, probably you're not going to feel much like driving.
Have you had a chance to read 7B4 where it mentions aircraft?
Yes.
Would that be any different?
No.
In other words, if we ruled in Mr. Hunt's favor, pilots could then fly airplanes while smoking marijuana cigarettes as long as it doesn't affect their ability to operate the motor vehicle?
Well, yes, that's what would be in B4. I mean, yeah, because it lists all those. It lists motor vehicles, aircrafts, motorboats. I still suggest that that's not an implicit repeal of the motor vehicle code. It just isn't, and it doesn't make sense that it would be.
Well, then it'd also have to, if Mr. Hunt's correct, it would also have to repeal portions of Michigan's law affecting who can and cannot fly an airplane and under what conditions they can fly that particular airplane.
Right. Getting into the aircraft law is a little bit out of my league. However, under the I know you can't drive with a .04 or greater. It's an 02 actually for planes commercially. It's an 04. So there are per se, statutes covering everything, and it seems to me the aircraft would be allowed just like a motor vehicle would be allowed. If you're looking at paragraph B4 of subsection 7 in the same way.
Thank you.
I'm sorry, I have one other question, and I'm glad you brought up the judge's opinion again, because I went back and took a look, and I had written a number of notes about the use of impairment instead of operating under the influence. But the one question I'm wondering, the trial court cites People versus Darer. You're familiar with him citing that case? Okay. And the Darer court identified this inconsistency, which had held that the stated objective of 257-6258 is to prevent persons from driving with any amount of a Schedule I controlled substance in the body, whether or not the substance is still influencing them. And he cites, the court at that point. So how do you respond to that? Because basically what it looks like the trial court was saying is that the Darer court actually held that we're not talking about influence, we're just talking about it being there, being in the system.
Right, except for the Darer case was carboxy-THC.
Right.
And while carboxy-THC, there are studies that say it can affect you. In Michigan, really, that was overruled by People versus Fiesel, and so we don't use that anymore in prosecution.
So he was just citing this because, I'm trying to remember when he signed this, so this would have been back in
2010.
Yeah, so maybe it was
April, maybe, or
it was
before Fiesel for sure.
Yeah, okay, so it was before Fiesel.
Yes,
That's
it
my
was.
question. Okay.
Yes.
All right. But I thought
Well, and it's true, outward impairment
Yeah, he did say
isn't
diesel.
part of what paragraph 8 is about. I agree with you. It's a per se violation. Just
Okay.
like an 08 and the 3-3 that you referred to in your defendant who came in to offer a plea was a 3-3. They walked and talked fine, and you'd be surprised. I just had a .4 not too long ago who didn't drive all that well, but still could ambulate quite well. That doesn't, it's still a per se violation, even if they didn't commit
Okay,
an act of influence.
I appreciate your time, and you did a very nice job as well.
Thank you very much.
Thank you.
Very much.
This case is submitted.